Voir Dire. A prosecutor walks into jury selection knowing exactly who she wants. Not the fairest minds. The ones she can win with. Across the room, the defense attorney has the same goal. They're not looking for impartial jurors. They're looking for favorable ones. And the entire process is designed to let them hunt. This is Voir Dire, the jury selection phase where attorneys don't just ask questions. They engineer the verdict before the trial even starts. It's sold as a search for fairness, but in practice, it's a psychological battlefield. The wrong answer to a single question can get you dismissed before you hear a word of testimony. Attorneys ask about backgrounds, beliefs, experiences. Do you trust police? Ever been a victim of crime? Think corporations care more about profits than safety? The answers expose vulnerabilities, opinions that can be exploited or eliminated. Because here's the reality: attorneys aren't filtering out extremes. They're building a jury that aligns with their narrative. A prosecutor in a drug case doesn't want someone who thinks the war on drugs is broken. A defense attorney in a police shooting doesn't want someone whose cousin is a cop. Every question is a test. Every answer is leverage. The system gives attorneys two weapons. First, challenges for cause. Clear bias. Gun. Personal connection. Gun. But these need judicial approval, and judges don't dismiss lightly. The second is dead layer, the Peremptory Strike. No reason required. An attorney can remove a juror because they don't like the tone, the vibe, how someone answered about reasonable doubt. Each side gets a handful of these strikes. Use them right, and you tilt the trial. Waste them, and you're stuck with jurors who might destroy your case. Strategy gets ruthless fast. Prosecutors in death penalty cases hunt for jurors who support execution but follow the law. Defense attorneys look for holdouts, that one person in 12 who won't fold under pressure. A single juror who values presumption of innocence over circumstantial evidence can mean acquittal. There's a darker history here. Peremptory strikes were used to exclude black jurors, women, anyone outside the ideal profile. The Supreme Court created the Batson challenge to stop this, forcing attorneys to justify discriminatory-looking strikes. But the system still bends. Attorneys craft neutral-sounding reasons that hide bias. She seemed distracted. He avoided eye contact. Batson raised the bar. It didn't end the game. In major cases, jury consultants arrive. Psychologists who analyze body language, word choice, micro-expressions. They build profiles, flag risks. It's no longer intuition. It's science. By the time the jury is seated, the trial hasn't started, but the outcome is already being shaped. 12 people who were supposed to be impartial have been filtered and selected based on how they'll likely respond. Voir dire isn't about finding fairness. It's about finding advantage. The trial is the performance. Jury selection is where the script gets written. Impeachment by prior inconsistency. A witness takes the stand, swears to tell the truth, gives clear testimony. The jury listens, forms a picture. Then cross-examination begins. The attorney pulls out a transcript, a police report, a recorded statement from months ago. You said the car was going fast. But 3 days after the accident, you told police you weren't sure of the speed. Which is it? The witness hesitates, tries to explain. The damage is done. The jury just watch credibility crack in real time. This is impeachment by prior inconsistency. It doesn't require proof of lying, just proof that the story changed. And once doubt enters, everything the witness said becomes questionable. The power lies in how juries process inconsistency. People expect truth to stay stable. If you saw something, your account shouldn't shift between Tuesday and Thursday. So when a witness says one thing under oath and something different earlier, it doesn't look like a mistake. It looks like manipulation. Even minor inconsistencies plant doubt. Attorneys hunt for this from day one. Before trial, they comb through every statement the witness ever made. Police interviews, depositions, emails, social media. They're looking for shifts in detail, changes in emphasis, anything that can be weaponized during cross. And here's the key, it doesn't need to be major. I saw him leave around 9, versus sometime after 8:30 is enough. Once the attorney highlights it, the witness has to explain. And every explanation sounds like backtracking. The jury sees defense, and defense looks weaker than certainty. The mechanics are surgical. The attorney reads the prior statement, asks the witness to confirm it, then asks them to confirm today's testimony. The contradiction hangs there. No theatrics needed. In criminal cases, this can demolish a prosecution witness. A victim who said black jacket in the police report but testifies to blue at trial just handed the defense reasonable doubt. It doesn't matter if trauma distorted memory. The jury sees inconsistency. Inconsistency means unreliability, but it cuts both ways. A defendant who shifts details between lawyer meetings and the stand gives prosecutors the same weapon. Credibility is fragile. Prior inconsistency is a sledgehammer. Attorneys try to soften the blow by preparing witnesses, walking them through every prior statement, flagging contradictions early. If unavoidable, they address it on direct examination, framing it as honest correction before the other side weaponizes it. I initially said 9, but thinking it through, closer to 8:30, sounds better from your own lawyer than during hostile cross. Still, once it's out there, it lingers. Jurors don't forget. A witness who seemed solid suddenly seems fallible. And in trials where credibility is everything, fallibility loses cases. Impeachment by prior inconsistency doesn't prove lying. It just proves memory shifts, that stress and time distort details. But in a courtroom, being human looks like weakness. And weakness loses. Jury nullification. The evidence is overwhelming. The defendant clearly broke the law. The judge instructed the jury to convict if the facts prove guilt beyond reasonable doubt. The jury deliberates. Then they come back with a verdict, not guilty. The law says guilty. The jury says no. This is jury nullification. The power jurors have to acquit even when the law demands conviction. It's not written in jury instructions. Judges rarely mention it. But it exists, embedded in the structure of the system itself, because once a jury decides, no one can overrule them. The concept is simple. Juries decide guilt. That's the job. But juries are also people, and people can reject the law itself. If a jury thinks a law is unjust, or that applying it in a particular case would be wrong, they can refuse to convict. The prosecution can't appeal an acquittal. The judge can't reverse it. The verdict stands. Historically, this has been used for both justice and injustice. In the 1800s, northern juries refused to convict people who helped escaped slaves, even though the Fugitive Slave Act made it illegal. The law was clear. The juries ignored it. During Prohibition, juries routinely acquitted bootleggers, signaling that they didn't support alcohol bans. The pattern was clear: when the public thinks a law is wrong, juries sometimes refuse to enforce it. But nullification cuts both ways. In the Jim Crow South, all white juries refused to convict white defendants for violence against black victims, no matter how clear the evidence. The law said guilty. The juries said no. Nullification became a tool of oppression, a way to ensure certain people stayed above the law. Today, it shows up in cases involving mandatory minimum sentences, drug possession, self-defense. A jury might believe the defendant technically broke the law, but doesn't deserve decades in prison for a small amount of marijuana. Or they might think someone acted in genuine self-defense even if the strict legal definition doesn't quite fit. So they acquit. Defense attorneys can't explicitly ask for nullification. If they tell a jury to ignore the law, the judge will shut it down, possibly declare a mistrial. But they can argue around it. They can emphasize the harshness of the punishment, the circumstances, the human cost. They can make the jury feel that convicting, even if legally correct, would be wrong. Prosecutors hate nullification because it undermines the rule of law. If juries can pick and choose which laws to enforce, the system becomes unpredictable. Laws stop meaning what they say. But defenders of nullification argue it's a check on unjust laws, a way for ordinary people to reject government overreach. The tension sits at the core of the jury system. Juries are supposed to follow the law, but they also represent the community, and sometimes the community rejects what the law demands. Nullification is the gap between legal and just. And that gap doesn't close. It just shifts depending on who's sitting in the jury box. Daubert challenge. Expert witnesses can decide cases. A forensic analyst says the fingerprint matches. A medical examiner says the injury came from blunt force trauma. A psychologist says the defendant shows signs of psychopathy. The jury listens, assumes the expert knows, and the testimony becomes fact. But what if the science isn't actually science? This is where the Daubert challenge comes in, a legal tool that forces courts to scrutinize whether an expert's methods are scientifically valid before the jury ever hears them. It's named after a Supreme Court case involving birth defects and disputed pharmaceutical evidence. The ruling established that judges act as gatekeepers, filtering out junk science before it reaches the jury. The standard asks whether the expert's methodology is testable, peer-reviewed, has a known error rate, and is generally accepted in the relevant scientific community. If the answer is no, the testimony gets excluded. The jury never hears it. The case can collapse. Defense attorneys use Daubert challenges to attack prosecution experts. Bite mark analysis. Questioned. Hair comparison. Challenged. Arson investigation based on outdated burn patterns. Thrown out. For decades, these methods were treated as solid forensic science. Then research showed they were unreliable, sometimes flat out wrong. Daubert became the tool to keep them out of court. Prosecutors face the same scrutiny. A defense expert claims the defendant has a mental disorder that explains their behavior. The prosecutor files a Daubert motion, demanding proof that the diagnosis method is scientifically sound. If the expert relied on a fringe theory or personal opinion rather than accepted science, the testimony gets blocked. The stakes are enormous. In criminal cases, expert testimony often provides the only link between defendant and crime. DNA analysis, ballistics, digital forensics. These shape verdicts. If the expert gets excluded, the prosecution's case can evaporate. If questionable testimony gets in, innocent people can be convicted based on methods that don't hold up under scrutiny. The problem is that judges aren't scientists. They're tasked with evaluating complex scientific questions, statistical reliability, methodological soundness, peer review standards, without the training to assess them. So they rely on dueling experts, each side presenting their own specialist to argue whether the other side's science is legitimate. It becomes a battle of credibility, and sometimes the more persuasive expert wins even if the science is shaky. Daubert also exposes how much courtroom science isn't actually scientific. Forensic disciplines that law enforcement relied on for decades. Handwriting analysis, bullet lead comparison, even some fingerprint techniques haven't been rigorously tested. They were grandfathered in, assumed reliable because they'd always been used. Daubert forces the question, where's the proof? Some fields have tightened standards in response. DNA analysis became more rigorous. Digital forensics developed clearer protocols. But other areas remain contested. Forensic odontology, gait analysis, certain psychiatric evaluations. Experts still testify and Daubert challenges still get filed. The challenge doesn't guarantee exclusion. It just demands scrutiny. And in a system where expert testimony can mean the difference between conviction and acquittal, scrutiny matters. Because once junk science reeks a jury, it's nearly impossible to undo the damage. Brady Material. The prosecution has evidence that could help the defense. A witness statement contradicting the key testimony. A police report showing the defendant was somewhere else. Lab results that weaken the forensic link. And they're required by law to turn it over. But what if they don't? This is the Brady Rule, named after a Supreme Court case that established prosecutors must disclose evidence favorable to the defense. It's not optional. It's a constitutional requirement. Withholding it violates due process. But the system relies on prosecutors deciding what's favorable, and that creates room for things to disappear. The rule sounds straightforward. If evidence could help the defendant, hand it over. But in practice, it's murky. Prosecutors don't always agree on what counts as favorable. A witness who gives inconsistent statements, does that help the defense or just show the witness is confused? A detective's notes mentioning an alternate suspect. Is that exculpatory or just speculation? These judgment calls shape what gets disclosed. And some prosecutors push the line. They bury evidence in massive document dumps, making it nearly impossible for defense attorneys to find the useful material. They argue that certain evidence isn't material, meaning it wouldn't have changed the outcome, so they didn't need to disclose it. They redact names, withhold witness contact information, delay disclosures until right before trial when there's no time to follow up. When Brady violations surface, they usually show up years later. A conviction gets overturned because new evidence reveals the prosecution withheld a police report. An exoneration happens because someone finally uncovers the alibi witness the state never mentioned. By then, the defendant has spent years in prison. The Brady rule existed. It just wasn't followed. The consequences for prosecutors who violate Brady are minimal. Courts rarely impose sanctions. Prosecutors claim they didn't realize the evidence was material, or that it was an oversight, or that defense counsel should have asked for it. Even when violations are clear, retrials happen, but careers don't end. The incentive structure doesn't change. Defense attorneys file Brady motions demanding disclosure, knowing they're asking prosecutors to undermine their own case. Sometimes it works. A prosecutor hands over impeachment material on a key witness, and the defense uses it to destroy credibility at trial. More often, defense attorneys suspect evidence exists but can't prove it, and by the time they find out, it's too late. The system assumes prosecutors will act in good faith, prioritizing justice over wins. But prosecutors are advocates. Their job is conviction. When favorable evidence sits in their files, the pressure to withhold it is real. Not malicious, necessarily, but strategic. And strategy beats rules when no one's watching. Brady doesn't require prosecutors to investigate for the defense or to highlight the best exculpatory material. It just requires disclosure. But even that minimal standard fails when the only person who knows evidence exists is the same person deciding whether to share it. The rule depends on honor. And in an adversarial system, honor isn't enough. Hearsay exception. Someone didn't see the crime. They heard about it. The witness on the stand is repeating what someone else told them. It's secondhand. It's hearsay, and technically it's not allowed. Except when it is. Hearsay rules exist to keep unreliable evidence out of trials. If you didn't witness it yourself, your testimony is just passing along someone else's words, and there's no way to cross-examine the original source. The person who actually saw what happened isn't under oath. Their credibility can't be tested. So courts block it. But the legal system carved out exceptions, dozens of them, situations where hearsay is allowed because it's considered reliable enough or necessary enough to let in. And attorneys exploit these exceptions constantly. Excited utterance is one of the most common. If someone blurts out a statement in the immediate shock of an event, it's admissible. The theory is that people don't lie in moments of extreme stress. So a bystander who screams, "He just shot him," right after a shooting can have their words repeated in court even if they never testify. The excitement guarantees honesty, supposedly. Dying declarations work the same way. If someone makes a statement while believing they're about to die, it comes in. The reasoning, no one lies on their deathbed. A victim who whispers the shooter's name before losing consciousness gives the prosecution powerful evidence, even though there's no cross-examination, no chance to challenge the identification. Then there's present sense impression. If someone describes an event while it's happening or immediately after, their statement gets in. A passenger in a car says, That truck just ran the red light. And later, even if the passenger doesn't testify, their words can be repeated to prove fault. Business records create another opening. Documents created in the regular course of business. Medical charts, shipping logs, receipts, are hearsay but admissible because companies don't fabricate routine records. A hospital record noting injuries consistent with assault becomes evidence without the nurse who wrote it ever taking the stand. These exceptions make trials faster. Calling every potential witness is impractical. Sometimes witnesses disappear, refuse to testify, or die before trial. Hearsay exceptions let prosecutors and defense attorneys build cases even when direct testimony isn't available. But they also let unreliable evidence in. Excited utterances assume stress guarantees truth, but people misidentify, confuse details, and panic under pressure. Dying declarations assume honesty, but dying people can be mistaken. Business records assume accuracy, but data entry errors happen, and records reflect what was written, not necessarily what occurred. Defense attorneys fight hearsay when it hurts their case and use exceptions when it helps. Prosecutors do the same. A defendant's out-of-court statement to a friend admitting guilt. That's a party admission exception, hearsay but admissible. A witness who told police one story but now refuses to testify. The prior statement might come in as past recorded recollection. The rules are complicated, full of subcategories and conditions. Attorneys spend careers learning which exception applies when. Judges make split-second rulings on whether a statement fits the criteria. And juries hear evidence that, under the basic hearsay rule, should never reach them. The system treats these exceptions as narrow, carefully controlled. But in practice, they're wide enough to let in nearly anything if an attorney argues it right. Hearsay law pretends to protect reliability. What it actually does is shift the question from, is this trustworthy, to does this fit an exception? And once it fits, trustworthy or not, the jury hears it. Fruit of the poisonous tree. The confession is detailed. The defendant admits everything. But the police never read Miranda rights. The confession gets thrown out. Then the prosecutor tries to use evidence found because of that confession. A weapon the defendant mentioned. Drugs recovered from a location, he disclosed. The prosecution argues the evidence is real, physical, independently valid. The judge says no. The evidence goes too. This is fruit of the poisonous tree, the legal doctrine that evidence derived from illegal police conduct gets excluded, even if the evidence itself was obtained legally. The original violation poisons everything that flows from it. If the tree is rotten, the fruit doesn't matter. The rule exists to deter police misconduct. If officers could violate rights and still use the evidence they found as a result, the violation would be worth it. So, courts exclude not just the primary evidence, but everything discovered because of it. The chain breaks at the source. It shows up most often with illegal searches and coerced confessions. Police search a home without a warrant, find a laptop, use the laptop to identify accomplices. The laptop gets excluded because the search was illegal. But so do the accomplice identities, the subsequent arrests, any statements those accomplices made. The entire investigation collapses backward from the original violation. Defense attorneys hunt for poisonous trees. They file motions to suppress, tracing evidence back to its origin. If the first step was illegal, everything after falls. A traffic stop without reasonable suspicion. Poisonous tree. Evidence found during that stop. Fruit. Statements made after. Also fruit. The case unravels. Prosecutors fight back with exceptions. Independent sources won. If police would have found the evidence anyway through a separate, legal investigation, it comes in. Inevitable discovery works similarly. If the evidence would have been discovered regardless of the violation, the poisonous tree doesn't apply. Then there's attenuation. If enough time or events separate the illegal act from the discovery of evidence, the connection weakens. The fruit is no longer poisonous because the link back to the tree has been broken. A defendant is illegally arrested, released, then voluntarily returns to confess days later. The confession might survive because the illegal arrest and the confession are attenuated, separated by time and choice. Good faith is another exception. If police relied on a warrant that later turned out to be invalid, evidence found during the search can still come in. The officers acted in good faith. The tree wasn't poisonous because there was no intentional misconduct. These exceptions create constant litigation. Defense argues the tree is poisonous. Prosecution argues an exception applies. Judges weigh whether the connection is direct enough, whether police acted in good faith, whether the evidence would have surfaced anyway. The fruit doctrine is clear in theory. In practice, it's a fight over how far the poison spreads. When the doctrine works, it can gut a prosecution. Cases built on evidence chains collapse when the first link breaks. When exceptions apply, convictions survive despite violations. The tension sits at the core of the rule: punish police misconduct or let reliable evidence in. The fruit doctrine picks punishment, but the exceptions show the system isn't willing to pick it every time. Peremptory strike. Jury selection gives attorneys power to remove jurors without giving a reason. No explanation, no justification, just gone. This is the peremptory strike, and it's one of the bluntest tools in trial strategy. Unlike challenges for cause, which require proving bias, peremptory strikes are pure discretion. An attorney doesn't like how someone answered a question. Strike them. Bad vibe. Strike. Too sympathetic to the other side. Strike. Each side gets a limited number, usually 6 to 10 depending on the case. Once they're used up, you're stuck with whoever's left. So attorneys choose carefully. Every strike is a gamble. Use it on the wrong juror, and you might need it later for someone worse. The strategy is surgical. Prosecutors strike jurors who seem skeptical of police, who've had bad experiences with the system, who might demand a higher standard of proof. Defense attorneys strike jurors who trust authority too much, who've been victims of crime who lean toward conviction. But peremptory strikes have a dark history. For decades, they were used to systematically exclude people based on race and gender. All white juries in the South weren't accidents. They were the result of prosecutors using peremptory strikes to remove every black juror from the pool. Defense attorneys did the same when it served their interests. The Supreme Court tried to stop this with the Batson challenge, which forces attorneys to justify strikes that appear discriminatory. But peremptory strikes still allow for manipulation. Attorneys just learn to craft neutral-sounding reasons. She seemed inattentive. He gave short answers. The language changed. The outcome often didn't. Some legal scholars argue peremptory strikes should be eliminated entirely. If the goal is an impartial jury, why let attorneys remove people for no reason? But defenders of the system say peremptory strikes allow attorneys to remove jurors they genuinely believe will be unfair, even when they can't prove bias to a judge's satisfaction. The reality is peremptory strikes give attorneys control, and control shapes verdicts. A prosecutor who strikes every juror with a college degree changes the jury's analytical capacity. A defense attorney who strikes every retired police officer changes how the jury views law enforcement testimony. By the time strikes are exhausted, the jury isn't random, it's curated. And both sides know it. Peremptory strikes aren't about fairness. They're about advantage. The system lets attorneys engineer the jury, and then calls it justice. Batson challenge. The prosecutor uses a peremptory strike to remove a black juror. Then another. Then a third. A pattern emerges. The defense attorney stands. Your Honor, Batson challenge. The judge pauses. This is the moment where the prosecutor has to explain. Not just strike jurors and move on. Explain why race wasn't the reason. Batson challenges exist because peremptory strikes were being used to build all white juries in cases with black defendants. The Supreme Court ruled in Batson v. Kentucky that using peremptory strikes to exclude jurors based on race violates the Equal Protection Clause. The same rule later extended to gender and other protected classes. The process is straightforward. The challenging attorney argues that the strikes show a discriminatory pattern. The burden shifts to the other side to provide race-neutral reasons. Then the judge decides whether those reasons are genuine or pretextual. In practice, it's a game of plausible deniability. Prosecutors and defense attorneys know they can't say, "I struck her because she's black." So they offer reasons that sound neutral. She seemed disengaged. Her body language was closed off. She didn't make eye contact. Judges face an impossible task. They're supposed to assess whether the attorney is telling the truth about their reasons, but there's no way to know what someone was really thinking. A prosecutor who says a juror seemed distracted might be telling the truth. Or they might be lying, using a neutral-sounding excuse to cover discriminatory intent. Studies show Batson challenges rarely succeed. Attorneys have learned to document neutral reasons during voir dire, building a record that survives scrutiny. They take notes on juror behavior, flag answers that seem evasive or inconsistent, and use those observations to justify strikes. And because peremptory strikes don't require reasons in the first place, attorneys only have to explain after a Batson challenge is raised. By then, they've already decided who to strike. They just need to justify it in hindsight. Some jurisdictions have tried to strengthen Batson by requiring more specific reasons or by presuming discrimination when certain patterns emerge. But the burden remains on the challenging party to prove intentional discrimination, and intent is nearly impossible to prove when attorneys know how to mask it. Defense attorneys use Batson too, challenging prosecutors who strike minority jurors. But prosecutors can also raise Batson challenges when defense attorneys use strikes in ways that appear discriminatory. The rule is bidirectional. It doesn't favor either side. It just tries to prevent the most blatant abuses. Batson didn't eliminate discriminatory jury selection. It raised the cost. Attorneys can still shape juries along racial lines. They just have to be smarter about it. The challenge exists, but the strikes continue. And the juries that result still don't look like the communities they're supposed to represent. Reasonable doubt framing. What does reasonable doubt actually mean? The prosecution has to prove guilt beyond it. The defense has to create it. But nobody defines it clearly, and that vagueness becomes a weapon. Prosecutors frame reasonable doubt as high but reachable. They tell juries it's not absolute certainty, not beyond all doubt, just beyond a reasonable one. They use metaphors. You don't need to see every piece of a puzzle to know what the picture shows. You don't need video footage to know what happened. The goal is to lower the bar without saying they're lowering it. Defense attorneys do the opposite. They frame reasonable doubt as closer to certainty. They remind juries that a person's freedom is at stake, that the state has all the resources, that doubt should favor the accused. They point to gaps in the evidence, inconsistencies in testimony, unanswered questions. Every gap becomes reasonable doubt. Jury instructions try to define it, but the language stays abstract. A doubt based on reason and common sense, not a fanciful or speculative doubt. These phrases don't clarify. They shift the question from what reasonable doubt is to what counts as reasonable. Prosecutors argue that defense attorneys inflate doubt, turning minor inconsistencies into major questions. A witness misremembers a detail. That's not reasonable doubt. That's normal human error. They frame the defense's argument as asking for an impossible standard, suggesting that no case could ever meet it if every small gap mattered. Defense attorneys argue the opposite. If there's doubt, and it's based on the evidence, it's reasonable. A missing witness, doubt. A timeline that doesn't quite line up, doubt. The absence of forensic evidence when it should exist, doubt. Doubt. They argue that the state chose to bring the case, chose this evidence, and if it's not enough, that's the state's problem. Judges sometimes intervene when framing goes too far. A prosecutor who suggests reasonable doubt means beyond most doubt or strong probability can draw an objection. A defense attorney who implies reasonable doubt means absolute certainty can get corrected. But the line between acceptable framing and improper argument is thin and inconsistently enforced. Closing arguments become battles over what reasonable means. Prosecutors use examples. You didn't see your neighbor leave for work this morning, but you know they did because their car is gone. The implication you can be sure of things without direct proof. Defense attorneys counter with their own examples. You don't convict someone of a crime because you think they probably did it, or the lack of a clear definition benefits whoever frames it better. In cases with strong evidence, prosecutors frame doubt as unreasonable nitpicking. In weak cases, defense attorneys frame the gaps as reasonable and fatal. The same standard argued opposite ways, and the jury decides which framing feels right. Reasonable doubt is supposed to protect the innocent. But in practice, it's a narrative tool. Whoever tells the more convincing story about what doubt means often wins. And that turns the burden of proof into a question of persuasion. Witness impeachment. A witness testifies. The other side doesn't believe them. So they attack. Not the testimony, the witness. This is impeachment, the process of undermining a witness's credibility so the jury stops believing what they say. It doesn't require proving they lied, just proving they might have. The simplest form is prior inconsistent statements. If a witness said something different before trial, the attorney confronts them. You told the detective the car was blue. Now you're saying black. Which is it? The inconsistency doesn't need to be major. Any shift plants doubt. Then there's bias. Does the witness have a reason to lie? A family relationship with the defendant, a financial interest in the outcome, a grudge against one of the parties. Attorneys expose these connections to suggest the testimony isn't neutral. Character impeachment hits harder. If a witness has a criminal record, especially for crimes involving dishonesty, the other side can bring it up. A witness convicted of fraud or perjury loses credibility fast. Even unrelated crimes can damage how a jury perceives them. Perception and memory attacks work too. Was the witness far away? Was it dark? Were they distracted? If the conditions make accurate observation unlikely, the testimony becomes questionable. A witness who saw something from 100 yards away at night while driving doesn't inspire confidence. Contradiction by other evidence is another tool. If the witness says the defendant was at the scene, but security footage shows otherwise, the footage impeaches the witness. The jury has to choose between testimony and physical evidence, and evidence usually wins. Cross-examination is where impeachment happens. The attorney doesn't ask open questions. They control the witness, forcing yes or no answers, boxing them into contradictions. A skilled cross can make an honest witness look unreliable and a dishonest witness look obvious. Witnesses try to recover. They explain inconsistencies, justify why their memory changed, clarify what they meant. But explanations sound defensive. The more a witness has to explain, the weaker they seem. Jurors start wondering why the story needs so much clarification if it's true. Prosecutors and defense attorneys both use impeachment. A defense attorney impeaches the state's key witness, and the case collapses. A prosecutor impeaches the defendant's alibi witness, and the alibi falls apart. Some impeachment is fair, pointing out genuine inconsistencies, exposing actual bias, questioning whether someone could really see what they claim. These are legitimate. But impeachment can also distort. A witness with a minor prior conviction gets painted as a liar. A witness who misremembers one detail gets treated as unreliable about everything. The jury doesn't get a manual on how much impeachment should matter. They just hear the attack and decide whether to believe the witness afterward. And once credibility cracks, it's hard to repair. Impeachment doesn't need to prove a witness is lying. It just needs to make the jury uncertain. And uncertainty is enough. Character evidence bar. You can't tell a jury the defendant is a bad person. You can't bring in evidence that they've done bad things before. that they have a violent temper, that people who know them say they're dishonest, even if it's true. This is the character evidence rule, one of the most rigid exclusions in trial law. The prosecution can't use a defendant's general character or past bad acts to suggest they're guilty of the current charge. The reasoning is simpler: people should be tried for what they did, not for who they are. If character evidence came in freely, trials would turn into referendums on whether the defendant is a good or bad person. Prosecutors would parade witnesses saying the defendant is aggressive, dishonest, reckless. Juries would convict based on character rather than proof of the specific crime. But the rule has exceptions, and they're significant. If the defendant puts their own character in issue by claiming they're peaceful, honest, or law-abiding, the prosecution can respond with evidence that they're not. It's a strategic choice to assert good character and open the door, or stay silent and keep it closed. Prior bad acts can come in for specific purposes. Not to show the defendant is a bad person generally, but to prove motive, opportunity, intent, or pattern. A defendant charged with arson who has a history of setting fires. That might come in to show knowledge and intent. A defendant charged with fraud who ran similar schemes before. That might show a common plan. The distinction is supposed to be clear. Evidence of character excluded. Evidence of specific acts for a specific purpose may be allowed. But in practice, the line blurs. A jury hears the defendant committed similar crimes before, and even if the judge instructs them to consider it only for intent, they can't unhear it. The evidence does double work, proving the specific point and poisoning general credibility. Defense attorneys fight to keep prior bad acts out. They argue the prejudice outweighs any legitimate purpose, that the jury will misuse the evidence no matter what the instruction says. Prosecutors argue the evidence is essential, that without it the jury can't understand the full picture. Judges decide on a case-by-case basis, weighing probative value against unfair prejudice. If the prior act is too similar to the charged crime, it might be excluded as overly prejudicial. If it's distinct enough and serves a clear purpose, it comes in. Victims face different rules. In sexual assault cases, the defendant generally can't introduce evidence of the victim's sexual history. Rape shield laws block this, preventing defense attorneys from suggesting a victim's past behavior makes the current accusation less credible. The rules recognize that character attacks on victims can be as unfair as character attacks on defendants. But exceptions exist here too. If the prior sexual conduct directly relates to the case, if it's the source of physical evidence, or if it provides an alternative explanation for what happened, it might come in. The character evidence rule reflects attention. Jurors want to know who the defendant really is. But trials are supposed to be about specific acts, not general reputations. The rule tries to keep those separate. The exceptions acknowledge that sometimes you can't. And in the space between the rule and the exceptions, trials get fought. Prior bad acts rule. The defendant has a history, prior arrests, previous accusations, maybe even convictions for similar crimes. The prosecution can't mention any of it, unless they find an exception. The rule is clear: past bad acts don't prove current guilt. Juries aren't supposed to convict someone because they did something wrong before. They're supposed to convict based on what happened this time. So evidence of prior misconduct stays out, but exceptions let it back in. Not to show the defendant is a bad person generally, but to prove motive, intent, knowledge, or pattern. A defendant charged with arson who set fires before. That comes in to show they knew how. Someone accused of fraud who ran the same scheme twice. That shows common plan. The line between proving character and proving intent is thin. Prosecutors argue they're showing pattern. Defense attorneys argue it's just poisoning the jury. Judges decide case by case, weighing whether the evidence proves something specific or just makes the defendant look guilty. When prior acts come in, they dominate. A jury hears the defendant committed a similar crime before, and even with instructions to use it only for intent, the damage spreads. The evidence does double work, proving the technical point and suggesting the defendant is exactly the kind of person who would do this. Defense attorneys fight hard to exclude it. They argue prejudice outweighs probative value, that juries can't compartmentalize, that letting it in guarantees conviction regardless of the current evidence. Sometimes they win. Often they don't. The rule exists to keep trials focused on the crime charged. The exceptions exist because sometimes the past explains the present, and the gap between them is where cases get decided. Opening the door doctrine. A defense attorney argues their client has never been in trouble before. Clean record. Upstanding citizen. The jury nods along. Then the prosecutor stands up. Your Honor. They open the door. Once one side introduces a topic, the other side can respond with evidence that would normally be excluded. If the defense claims good character, the prosecution can bring in bad character. If the defense suggests the defendant wasn't capable of the crime, the prosecution can show prior similar acts. The doctrine prevents one side from making a misleading claim and then hiding behind evidentiary rules when the other side tries to correct it. You can't tell half the story and block the rest. But it's a trap. Defense attorneys have to be careful what they argue. Claiming the defendant wouldn't do this kind of thing. That might open the door to past conduct showing they would. Suggesting the defendant doesn't know how to commit the crime. That lets in evidence of expertise. Prosecutors use the same calculation. If they argue something that implies facts not in evidence, the defense can bring in rebuttal material that would otherwise stay out. Both sides watch for openings, waiting for the other to step too far. Judges control the door. They decide whether a statement actually opened it, how wide it swung, and what evidence can come through. A vague claim might crack the door slightly. A direct assertion might blow it open. The doctrine keeps both sides honest. It prevents strategic half-truths. But it also turns trials into verbal minefields where one wrong argument can let in devastating evidence. Attorneys don't just argue their case. They guard the door. Curative Instruction. A witness blurts out something they weren't supposed to say. A prior conviction. An inadmissible statement. Something the jury was never supposed to hear. The attorney objects. The judge sustains it. Then the judge tells the jury to disregard what they just heard. This is a curative instruction, the legal fiction that juries can unhear things. The judge instructs them to ignore the statement, to proceed as if it was never said. The trial continues. Except juries are human. Once they hear something, they can't forget it. A witness mentions the defendant was in prison before. That sticks, instruction or not. Someone says the victim was afraid of the defendant based on past violence. The jury remembers, even when told to disregard it. Attorneys know this. That's why prosecutors sometimes risk inadmissible questions. If the answer comes out before the objection, the jury hears it. The judge can instruct them to ignore it, but the seed is planted. Even if the instruction comes, the damage is done. Defense attorneys push for stronger remedies. A curative instruction isn't enough when the statement is devastating. They ask for mistrials, arguing that no instruction can undo the prejudice. Judges weigh whether the jury can actually follow the instruction or whether the trial is irreparably tainted. Some statements are so inflammatory that curative instructions don't work. References to insurance, prior crimes, inadmissible confessions. These can poison a trial beyond repair. When that happens, the only cure is starting over. But most of the time, the instruction is the remedy. The judge tells the jury to disregard, and the trial continues. Whether they actually do is another question. Courts operate on the assumption that juries follow instructions. The reality is murkier, and in close cases, what they were told to forget might be what tips the verdict. Mistrial Motion. Something goes wrong during trial. A witness says something prejudicial. An attorney makes an improper argument. A juror reveals they've been reading news coverage. The defense moves for a mistrial. They're asking the judge to stop everything, dismiss the jury, and start over. Mistrials are rare. Judges don't grant them lightly. Trials are expensive, time-consuming, and hard on everyone involved. So the bar is high. The error has to be serious enough that continuing would deny the defendant a fair trial. Prejudicial statements can do it. If a prosecutor tells the jury the defendant refused to take a polygraph, that's improper. Polygraphs aren't admissible. If the statement is bad enough and a curative instruction won't fix it, the judge might declare a mistrial. Juror misconduct is another trigger. A juror who discusses the case with outsiders, researches facts online, or visits the crime scene has violated their oath. If the misconduct is severe, the trial gets scrapped. Attorney misconduct can also lead to mistrials. A prosecutor who repeatedly violates evidentiary rules, who makes inflammatory arguments despite warnings, who intentionally provokes inadmissible responses. These can poison the trial beyond repair. But mistrials have consequences. In criminal cases, double jeopardy sometimes prevents retrial. If the mistrial was caused by prosecutorial misconduct designed to provoke it, the defendant might walk free. If it was caused by something outside the prosecution's control, retrial is allowed. Defense attorneys sometimes move for mistrials strategically. If the trial is going badly, a mistrial resets the board. But it's a gamble. The prosecution gets another chance, learns from their mistakes, and comes back stronger. Judges are cautious. They prefer curative instructions, limiting instructs, anything short of blowing up the trial. A mistrial means everyone starts over. New jury, new testimony, new months of preparation. It's the nuclear option. And courts only use it when nothing else will work. Expert qualification attack. An expert takes the stand. Credentials listed. Experience detailed. Opinions ready. Then the other side attacks. Not the opinion. The expert. Before an expert can testify, they have to be qualified. Education, training, experience. Enough to establish they actually know what they're talking about. If the opposing attorney can show they don't, the expert never testifies. The attack starts during voir dire of the expert. The attorney questions their credentials. Degrees from unaccredited institutions. Publications in fringe journals. Experience that doesn't actually match the case. Every gap gets exposed. Then comes methodology. Even a credentialed expert can be disqualified if their methods aren't reliable. Did they follow standard protocols? Is their analysis based on accepted science? Or did they custom build a theory just for this case? Daubert challenges are part of this. The attorney argues the expert's methods don't meet scientific standards. If the judge agrees, the expert's testimony gets excluded entirely. No credentials save you if your methodology is flawed. Bias is another angle. Does the expert only testify for one side? Do they get paid per case or per verdict? Are they a professional witness who will say whatever the attorney needs? Financial interest undermines credibility, and if it's strong enough, it can disqualify the expert. Experts try to defend themselves. They cite their publications, their cases, their peer recognition. But cross-examination is brutal. Every weak credential, every questionable case, every payment received gets highlighted. When an expert gets disqualified, it can collapse a case. Forensic testimony excluded. No link between defendant and crime scene. Medical opinion thrown out. No proof of cause of death. The attorney who qualified the expert failed at the gate. Courts take qualification seriously because juries defer to experts. If someone with a title says it, juries believe it. So the bar for getting on the stand has to be high. The expert has to actually be an expert. And if they're not, they don't testify. Subornation of Perjury. An attorney knows their witness is about to lie. Not misremember. Not exaggerate. Lie. And the attorney lets it happen anyway. That's subornation of perjury, and it's a crime. The rule is clear: attorneys can't knowingly present false testimony. If they know a witness will lie, they can't call them. If a witness lies on the stand and the attorney realizes it, they have to take action. Tell the court, withdraw the testimony, or withdraw from the case entirely. But knowledge is the key word. If the attorney suspects the witness might be lying but doesn't know for sure, the line gets murky. Attorneys aren't required to investigate every inconsistency or demand their witnesses prove every statement. They can present testimony they believe is false as long as they don't know it's false. This creates a gray area. A defendant tells their lawyer one story during preparation, then changes it on the stand. Did the attorney suborn perjury by letting them testify? Not if they didn't know the second version was false. Witnesses misremember, get nervous, change details under pressure. The attorney isn't required to assume perjury. But if the attorney actively coaxes the witness to lie, that's subornation. Telling a witness to change their story to fit the defense theory, suggesting they remember something differently, prepping them to deliver false testimony. All of that crosses the line. The consequences are severe. Attorneys who suborn perjury face disbarment, criminal charges, and personal liability. The case can be thrown out. Convictions can be overturned. The damage spreads beyond the individual trial. Yet it's hard to prove. Subornation requires showing the attorney knew the testimony was false and intentionally presented it anyway. Most attorney-client communications are privileged, so getting proof is difficult. Witnesses rarely admit they lied, and attorneys rarely admit they knew. Defense attorneys face particular tension. Their client might insist on testifying even when the attorney knows the testimony will be false. The attorney can't stop the client from taking the stand. That's the client's constitutional right. But they also can't assist in presenting perjury. The solution is often narrative testimony. The attorney asks the client to tell their story without leading questions, signals to the court that they're not vouching for it, and lets the client speak. It's not an endorsement. It's damage control. Subornation lives in the gap between advocacy and ethics. Attorneys push their case as hard as they can. But there's a line, and perjury is on the wrong side of it. Cross it, and the career ends. Sequestration Order. Witnesses sit outside the courtroom. They wait. They're not allowed to hear what anyone else says. This is sequestration, the rule that keeps witnesses separated so they can't tailor their testimony to match others. If a witness hears what the person before them said, they might adjust their story, consciously or not. Sequestration prevents that. The order is simple: witnesses stay out until they testify. Once they're done, some judges let them stay and watch. Others don't. The goal is the same: keep testimony independent. It works because witnesses can't coordinate. A co-defendant can't hear the prosecution's star witness and suddenly remember details that align. An alibi witness can't hear cross-examination and preemptively adjust their story to avoid the same traps. Defense attorneys and prosecutors both request sequestration when they suspect witnesses might influence each other. Judges usually grant it. The exceptions are narrow. Parties to the case, expert witnesses who need to hear testimony to form opinions, victim advocates in some jurisdictions. But sequestration isn't perfect. Witnesses still talk in hallways, compare notes during breaks, get debriefed by attorneys after they testify. The rule keeps them out of the courtroom. It doesn't keep them silent. Spoliation Inference. Evidence disappears. A defendant deletes emails. Surveillance footage gets erased. Documents vanish right before they were supposed to be handed over. The other side notices. They ask the judge to tell the jury that the missing evidence would have been damaging to the party who destroyed it. This is spoliation inference, the legal penalty for destroying evidence. If one side intentionally gets rid of material that was relevant to the case, the court can instruct the jury to assume it was harmful. Spoliation doesn't just lose the evidence. It creates a presumption of guilt. The rule exists because evidence destruction undermines justice. If someone can make damaging material disappear without consequence, they'll do it. Spoliation Inference makes destruction costly even when the evidence is gone. Proof of intent matters. Accidental deletion, routine document destruction before litigation starts, losing material without knowledge of its relevance. These don't trigger spoliation. The destruction has to be intentional and in bad faith. When spoliation is proven, the consequences can be severe. In civil cases, courts sometimes enter judgment against the party who destroyed evidence. In criminal cases, juries get an instruction that they're allowed to infer the missing material would have supported the other side's case. Defense attorneys use this when prosecutors lose evidence. Missing police reports. Body camera footage that wasn't preserved. The defense argues spoliation and asks the jury to assume the material would have helped acquit. Prosecutors use it when defendants destroy evidence. Wiped phones, deleted messages, shredded documents. If destruction is intentional, the inference runs against the defendant. Bruton Problem. 2 defendants. 1 trial. A confession. The confessor implicates the other defendant. The confession isn't admissible against the co-defendant because there's no chance to cross-examine. But the jury hears it anyway because it's admissible against the person who confessed. This creates the Bruton Problem, named after a Supreme Court case. Even if the judge instructs the jury to consider the confession only against the confessor, the damage spreads. Juries can't compartmentalize. They hear that one defendant said the other was involved, and it affects how they view the co-defendant's guilt. The solution is usually severance, separate trials. But prosecutors resist this. It's expensive, time-consuming, and forces the state to prove the same facts twice. So they look for ways around Bruton. One option is redacting the confession to remove references to the co-defendant. Men and John did it becomes men another person did it. If the redaction is thorough enough, the statement might come in. But if it's obvious whom another person is, the Bruton Problem remains. Another option is the confessor taking the stand. If they testify, the co-defendant gets to cross-examine, which cures the Bruton violation. But confessors rarely want to testify because it opens them up to cross-examination by their own co-defendant's attorney. When Bruton violations happen and convictions result, appeals follow. If the confession clearly implicated the co-defendant, and there was no severance or adequate redaction, the co-defendant's conviction can be overturned. Change of venue motion. The case is all over the news. Everyone in town knows the defendant's name, the victim's face, the details of the crime. Jury selection starts, and every potential juror has already formed an opinion. The defense moves to change venue. Take the trial somewhere else where people haven't been saturated with Mistrial publicity. Judges are reluctant to grant these. Changing venue is expensive and logistically difficult. It means moving attorneys, witnesses, evidence, and court staff to another jurisdiction. So the bar is high. The defendant has to show that finding an impartial jury locally is impossible. Mistrial publicity alone isn't enough. The publicity has to be so pervasive and inflammatory that no fair trial is possible. High-profile cases get media coverage everywhere, and courts assume voir dire can filter out bias. But sometimes the coverage is too much. A small town where everyone knows the victim. A case where local media has been running stories for months painting the defendant as guilty. A situation where community sentiment is so strong that jurors fear social backlash for acquitting. When venue changes get granted, the trial moves to a county far enough away that the publicity didn't saturate the population. The case gets tried under the same laws with the same charges, just in front of a jury that hasn't been primed to convict. Defense attorneys push for this in cases where they know local juries will be hostile. Prosecutors fight it because moving the trial disrupts their case and adds cost. Prejudicial publicity. A suspect gets arrested. The media runs their mugshot, lists their prior arrests, calls them dangerous. The case hasn't gone to trial yet, but the damage is done. This is prejudicial publicity, and it can poison the jury pool before selection even starts. Once potential jurors see headlines calling the defendant a monster, presumption of innocence becomes a legal fiction. The First Amendment protects press coverage. Courts can't stop media from reporting, but they can try to mitigate the effects. Judges issue gag orders limiting what attorneys and parties can say publicly. They delay trials to let publicity fade. They bring in juries from other areas less exposed to coverage. None of it fully works. In major cases, coverage is national. Changing venue doesn't help when every county has seen the same stories. Delaying trial just means the publicity lingers longer. Defense attorneys fight prejudicial publicity by moving to exclude jurors who've been exposed. During Voir Dire, they ask what potential jurors have seen, whether they've formed opinions, whether they can set aside what they've heard. Most say they can. Whether they actually do is another question. Prosecutors sometimes contribute to the problem. Press conferences where they detail evidence, statements calling the defendant guilty before trial, leaks to media. All of this can prejudice the jury pool. If it's egregious enough, it can lead to sanctions or mistrials. The tension is structural. Trials are public. Media covers them. The public forms opinions, and those opinions make their way into jury boxes, no matter what judges say about impartiality. Bench trial waiver. A defendant has the right to a jury trial, but they can give it up. This is a bench trial waiver where the defendant chooses to have the judge decide guilt instead of a jury. It's strategic. Sometimes juries are the problem. Cases involving technical evidence, complex financial crimes, or charges that trigger emotional reactions. These can be hard to win in front of a jury. Jurors struggle with dense expert testimony. They react emotionally to certain crimes. A judge, by contrast, has seen it all and can focus on the law. Defense attorneys waive juries when they think the evidence is strong but the law is on their side. A judge is more likely to apply legal standards strictly, exclude evidence properly, and base a verdict on technical deficiencies in the prosecution's case. Juries might convict anyway because the defendant seems guilty even if the evidence doesn't quite prove it. Prosecutors sometimes prefer bench trials too. In cases where the defendant is unsympathetic but the evidence is solid, a judge can deliver a guilty verdict without the risk of a single holdout juror causing a mistrial. Both sides have to agree to waive the jury, and the judge has to approve. The defendant has to make the choice knowingly and voluntarily. If they're pressured into it, the waiver doesn't hold. Bench trials move faster. No jury selection. No long deliberations. The judge hears evidence, applies the law, and issues a verdict. But they're also riskier. If the judge decides against you, there's no chance a single juror might have held out. The verdict is final. Defense attorneys weigh the gamble carefully. Juries are unpredictable. Judges are experienced. Which is worse depends on the case. Harmless error doctrine. A trial has errors. A judge lets in evidence that should have been excluded. An attorney makes an improper argument. The defendant appeals, points to the mistakes, and asks for a new trial. The appellate court says no. The errors were harmless. This is the harmless error doctrine, the rule that not every mistake requires reversal. If the error didn't affect the outcome, the conviction stands. Appeals courts don't retry cases over technicalities when the result would have been the same anyway. The test is whether the error was harmless beyond reasonable doubt. If the evidence against the defendant was overwhelming, a single evidentiary mistake won't overturn the verdict. If the case was close, the same error might require a new trial. Defense attorneys hate this doctrine because it means winning on appeal is hard even when errors occurred. Prosecutors rely on it to preserve convictions despite courtroom mistakes. Plain error review. The defense didn't object during trial. The error happened, but the attorney let it pass. Now on appeal, they want it fixed. Usually, that's too late. Appellate courts don't review issues that weren't raised at trial. But plain error is the exception. If the error was so obvious and so damaging that it affected the fairness of the trial, appellate courts can address it even without an objection. The bar is extremely high. The error has to be clear, it has to affect substantial rights, and it has to seriously undermine the integrity of the proceeding. Defense attorneys use plain error review as a last resort when they missed something critical at trial. Courts grant it rarely, reserving it for the most egregious mistakes. Cumulative error theory. One error might be harmless. Two might be harmless. But 10 errors. Cumulative error theory argues that even if no single mistake was bad enough to overturn a conviction, the combined effect of multiple errors can deny a fair trial. Small problems pile up until the trial itself becomes unreliable. Defense attorneys use this on appeal when they can point to a pattern of errors. Evidentiary rulings, jury instructions, prosecutorial statements that individually didn't cross the line but together created prejudice. Courts are skeptical. If each error was harmless on its own, adding them up doesn't always change the result. But in cases where errors stacked throughout the trial, cumulative error can be the argument that gets a conviction reversed. Burden-shifting argument. The prosecution has to prove guilt. The defense doesn't have to prove innocence. That's the fundamental rule. But prosecutors sometimes flip it. They argue that if the defense's theory was true, they would have presented certain evidence. The absence of that evidence means the defense is lying. This shifts the burden. It suggests the defense has to prove their version of events, not just create reasonable doubt about the prosecution's version. When it happens, defense attorneys object immediately. Judges are supposed to shut it down. The burden never shifts. But in closing arguments, the line gets blurred. A prosecutor who points out gaps in the defense case might be commenting on the evidence or improperly shifting the burden. The distinction matters, and it's litigated constantly. Adverse inference. A party refuses to testify. A defendant doesn't take the stand. A witness invokes the Fifth Amendment. The other side wants the jury to assume silence means guilt. That's an adverse inference, and in criminal cases involving defendants, it's prohibited. The jury can't be told that refusing to testify suggests guilt. But in civil cases, adverse inferences are allowed. If a party refuses to testify or produce evidence, the jury can be instructed to assume the missing material would have been unfavorable. The rule shifts depending on context. Criminal defendants have a constitutional right not to testify, and exercising that right can't be used against them. Witnesses who invoke the Fifth can sometimes trigger adverse inferences, but courts are careful about when and how. Defense attorneys fight adverse inferences when prosecutors try to sneak them in through comments about the defendant's silence. Prosecutors push back when defense witnesses refuse to cooperate, and the defense still expects favorable treatment. Consciousness of guilt evidence. A suspect runs from police. A defendant lies during questioning. Someone destroys evidence after the crime. Prosecutors argue these actions show consciousness of guilt. Innocent people don't run. They don't lie. They don't destroy evidence. So behavior suggesting someone knew they were guilty can be used to prove they are guilty. Defense attorneys fight this because the inference is weak. People run from police for reasons unrelated to guilt. Outstanding warrants, fear prior bad experiences. Lying during interrogation doesn't mean someone committed the crime, just that they were scared or didn't trust the system. Courts allow consciousness of guilt evidence, but require it to be relevant. Flight has to be connected to the crime, not just to general fear of law enforcement. Lies have to relate to material facts, not insignificant details. When it comes in, consciousness of guilt evidence is powerful. Jurors see someone acting like they're guilty and draw the obvious conclusion. Whether the behavior actually proves guilt is secondary. The impression sticks. Prior consistent statement. A witness testifies. The other side impeaches them with a prior inconsistent statement. Their credibility cracks. Then the attorney who called them fights back with a prior consistent statement, an earlier account that matches today's testimony. The goal is rehabilitation. If the witness said the same thing before consistently, the inconsistency looks less damaging. Maybe the inconsistent statement was the outlier, not the current testimony. But prior consistent statements don't come in freely. They're only admissible to rebut specific attacks. Charges of recent fabrication, claims of improper influence or motive. If the impeachment doesn't suggest the witness changed their story for a reason, the consistent statement stays out. When it works, it stabilizes credibility. The witness looks reliable again. The inconsistency becomes a blip rather than a pattern. Refreshing recollection. A witness can't remember a detail. The attorney hands them a document, notes, a report, a prior statement. The witness reads it, memory refreshes, and they continue testifying. This is refreshing recollection, and it's allowed because memory fades. The document itself doesn't come into evidence. It's just a tool to jog the witness's memory. Once refreshed, the witness testifies from recollection, not from reading. The opposing attorney gets to see what was used to refresh memory. If it's biased or misleading, they can challenge it. If the witness is just reading the document rather than actually remembering, the testimony can be excluded. It's a narrow tool. The witness has to have personal knowledge. The document has to genuinely refresh, not replace, their memory. When used properly, it saves testimony that would otherwise be lost to time. Recorded recollection. A witness once knew something but can't remember it now. Refreshing their recollection doesn't work. The memory is gone, but they recorded it when it was fresh, wrote it down, made a memo, filed a report. That recording can come into evidence as recorded recollection, not as a substitute for testimony, but as proof that the witness knew it at the time. The document gets read to the jury, but it doesn't go back to deliberations with them unless the other side offers it. The foundation requires proof. The witness has to confirm they made the record when the event was fresh. They have to verify it was accurate when made. And they have to acknowledge they can't remember enough now to testify fully. It's a workaround for faded memory. The witness testifies to the process of recording. The record testifies to the content. Offer of proof. A judge excludes evidence. The attorney argues it should come in, but the judge says no. The trial continues without it. Later, on appeal, the excluded evidence becomes an issue. But the appellate court needs to know what the evidence was and why it mattered. That's where the offer of proof comes in. When evidence gets excluded, the attorney makes a record, states what the evidence would have shown, why it was relevant, how it would have changed the case. Without an offer of proof, the appellate court can't assess whether exclusion was error. The attorney has to preserve the issue by putting it on the record, outside the jury's hearing. It's procedural but critical. Winning on appeal often depends on whether the record shows what was lost when evidence got excluded. Collateral matter rule. A witness testifies. The other side wants to impeach them on a detail that has nothing to do with the case. The judge blocks it. The detail is collateral, not relevant to any issue being tried. The rule prevents trials from spiraling into disputes over irrelevant facts. If a witness says they were wearing a blue shirt and the other side has evidence it was red, but the shirt color doesn't matter to the case, the impeachment is collateral. It's not allowed. Impeachment has to go to something that matters. Bias, motive, ability to perceive, truthfulness on material facts. These are fair game. Minor inconsistencies on irrelevant details are not. The rule keeps trials focused. Attorneys can attack credibility, but only on things that actually affect the case. Judicial Notice. Some facts don't need proof. The sun rises in the east. January has 31 days. Gravity exists. Courts can take judicial notice of facts that are common knowledge or easily verified. When a court takes judicial notice, the fact is accepted without evidence. No witness testifies about it. No document proves it. The judge simply acknowledges it's true, and the jury is instructed to accept it. The doctrine saves time. Attorneys don't have to prove obvious facts or waste resources establishing things no reasonable person disputes. Courts take judicial notice of laws, geographical facts, historical dates, scientific principles. But it's limited. The fact has to be indisputable. If it's subject to reasonable debate, it requires evidence. Judicial notice is for certainties, not for things parties might actually contest. Doctrine of Completeness. An attorney introduces part of a statement, a sentence, a paragraph, just enough to support their case. But the full statement says something different. The rest provides context that changes the meaning entirely. The other side invokes the doctrine of completeness. If one party introduces part of a statement, the opposing party can require the whole thing to come in. You don't get to cherry-pick the useful parts and hide the rest. The rule prevents misleading the jury. A partial statement can distort what was actually said. The defendant's confession might say, "I was there, but I didn't do it." If the prosecution only introduces, "I was there," the defense can force the rest in to show the full context. The doctrine applies to written statements, recorded conversations, documents. If you use part of it, the other side can complete it. The goal is fairness. Juries deserve the full picture, not selective editing. Attorneys still try to work around it. They introduce carefully chosen excerpts, hoping the other side won't notice what's missing. But when the doctrine gets invoked, the missing context comes in, and the partial statement loses its impact. Excited utterance. Someone witnesses a shooting. In the immediate shock, they scream, "He just shot him." Later, they refuse to testify or can't be found. The prosecutor wants to introduce what they said right after the shooting. It's hearsay. The witness isn't on the stand. There's no cross-examination, but it comes in anyway under the excited utterance exception. The theory is that people don't lie in moments of extreme stress. The shock of the event ensures honesty. Someone blurting out a statement while still reeling from what they saw is considered reliable, even though it's second-hand. The statement has to be made while under the stress of the event. Minutes later might work. Hours later probably won't. The excitement has to still be dominating the speaker's thoughts, leaving no time to fabricate. Defense attorneys challenge excited utterances by attacking the timing. Was there enough time for the person to calm down and think about what to say? If so, the exception doesn't apply. But if the statement came immediately, raw and unfiltered, it usually gets in. The exception is powerful because it lets prosecutors introduce statements from people who never take the stand. The defense can't cross-examine. They can only argue the statement shouldn't have come in at all. Dying declaration. A victim is shot. They know they're dying. In their final moments, they whisper the shooter's name to a paramedic. Then they're gone. That statement can come into evidence, even though the victim never testified. It's a dying declaration, an exception to hearsay based on the belief that no one lies when facing death. The rule requires the speaker to believe death is imminent. They have to know they're dying. A statement made before the belief sets in doesn't qualify. A statement made after doctors say they'll survive doesn't qualify either. The declaration has to concern the cause or circumstances of their impending death. A dying person's last words about an unrelated topic don't come in under this exception. It's one of the oldest hearsay exceptions, rooted in the idea that deathbed honesty is sacred. But it's also controversial. Dying people can be confused, mistaken, disoriented. They might misidentify. They might not know what happened. Defense attorneys attack dying declarations by questioning whether the speaker actually believed they were dying or whether they were coherent enough to make a reliable identification. But when the exception applies, the statement carries weight. Juries treat last words seriously. Authentication challenge. A prosecutor introduces a document, an email, a text message, a recording. The defense objects. How do we know it's real? How do we know it hasn't been altered? This is an authentication challenge, the requirement that evidence be proven genuine before it comes in. Documents don't authenticate themselves. Someone has to establish that the email actually came from the defendant, that the recording is accurate, that the signature is real. Authentication doesn't require perfection. It just requires enough evidence to support a finding that the item is what it's claimed to be. A witness can testify they sent the email. Metadata can show the source. Chain of custody can establish the recording wasn't tampered with. But if authentication fails, the evidence gets excluded. A document with no proof of origin is worthless. A recording with gaps in the chain of custody is suspect. A photo with no testimony about when or where it was taken doesn't come in. Defense attorneys use authentication challenges to exclude damaging evidence. If the prosecution can't prove the text came from the defendant, it stays out. If they can't establish the video is unaltered, it doesn't reach the jury. Authentication is the gatekeeper. Before evidence can be considered, it has to be proven real. And that burden is on the party trying to introduce it. Limiting instruction. Evidence comes in, but only for a specific purpose. A defendant's prior conviction is admissible to show motive, but not to prove bad character. The jury hears it. Then the judge gives a limiting instruction. You may consider this evidence only for the purpose of motive. You may not use it to conclude the defendant is a bad person. The instruction is supposed to cabin how the jury uses the evidence. They're allowed to consider it for one thing but not another. In theory, they compartmentalize. In reality, they hear it and it affects their view of the defendant regardless of what the judge says. Once the jury knows about a prior conviction, limiting how they think about it is nearly impossible. Attorneys request limiting instructions when evidence comes in for a narrow purpose. The instruction is supposed to prevent unfair prejudice, but its effectiveness is questionable. Jurors are human. They can't unhear things or neatly separate purposes in their minds. Defense attorneys sometimes prefer to keep evidence out entirely rather than accept a limiting instruction. Prosecutors argue the instruction is enough. Judges give the instruction and assume juries follow it. Whether they actually do is another matter. Invited error doctrine. A defense attorney makes a strategic choice during trial. They ask for a particular jury instruction. They request certain evidence be admitted. The judge agrees. Later, the verdict comes back guilty. On appeal, the defense argues the instruction was wrong or the evidence shouldn't have come in. The appellate court says no. You asked for it. You can't complain now. This is invited error, the rule that parties can't appeal mistakes they caused. If the defense requested the instruction, invited the evidence, or affirmatively agreed to a ruling, they waive the right to challenge it later. The doctrine prevents gamesmanship. Attorneys can't deliberately create error, lose at trial, and then use that error as grounds for reversal. If you invited it, you're stuck with it. There are exceptions. If the invited action violated a defendant's constitutional rights, appellate courts sometimes intervene. But for ordinary trial decisions, invited error bars appeal. The choice was made, and the consequences follow. Manifest necessity. A trial is underway. Then something goes catastrophically wrong. A juror reveals they've been researching the case online. A witness blurts out something so prejudicial no instruction can fix it. The trial can't continue fairly. The judge declares a mistrial. But mistrials trigger double jeopardy concerns. Can the defendant be retried, or does stopping the trial mean they walk free? Manifest necessity is the standard. If the mistrial was unavoidable, if continuing would have denied a fair trial and no lesser remedy would work, retrial is allowed. The necessity has to be genuine, not manufactured. Courts scrutinize whether the judge explored alternatives. Could a curative instruction have fixed it? Could the problematic juror have been replaced? If less drastic options existed and weren't used, the mistrial might bar retrial. Prosecutors can't engineer mistrials to get a second chance at a case that's going badly. If misconduct by the state provokes the mistrial, double jeopardy can attach. The defendant walks. Defense attorneys sometimes move for mistrials strategically, knowing that if granted, retrial might be blocked. Judges waive carefully. Declaring a mistrial is serious. It has to be necessary. Directed verdict, motion. The prosecution rests. The defense immediately moves for a directed verdict. They're arguing the state's evidence is so weak that no reasonable jury could convict. The judge should end the trial now and enter a not guilty verdict. It's a high bar. The judge views the evidence in the light most favorable to the prosecution. If any rational jury could find guilt beyond reasonable doubt based on what's been presented, the motion gets denied. The trial continues. But if the prosecution failed to prove an essential element of the crime, the motion succeeds. No witness placed the defendant at the scene. No evidence linking them to the act. The case collapses, and the defendant walks without the jury ever deliberating. Defense attorneys make these motions routinely, knowing most will fail. But when they succeed, it's a complete victory. No jury verdict to appeal. No retrial possible. The case is over. Prosecutors fight directed verdict motions by pointing to any evidence, however thin, that supports their case. As long as something is there, the motion fails and the jury decides. The motion is also a preservation tool. If the defense makes the motion and it gets denied, they can raise the same issue on appeal if convicted. Leading question trap. A question suggests its own answer. You were angry at the victim, weren't you? It's leading. On direct examination, where attorneys question their own witnesses, leading questions are generally prohibited. But on cross-examination, they're allowed. In fact, they're the primary tool. Cross is about control. Leading questions let attorneys box witnesses into yes or no answers, preventing them from explaining or wandering. The trap happens when attorneys accidentally lead on direct, or try to sneak leading questions past objections. A prosecutor questions their witness, and then the defendant threatened you, correct. The defense objects. Leading. The judge sustains. Now the prosecutor has to rephrase. What did the defendant say to you? The answer might not be as clean. The witness might hesitate or give a weaker response. The leading question would have locked in the desired answer, but it's not allowed. Defense attorneys use the same tactic on cross-examination to devastating effect. You didn't actually see who fired the shot, did you? Forces a yes or no answer. The witness can't explain. They're trapped. Judges police leading questions, but enforcement is inconsistent. Some allow more leeway on direct. Others are strict. Attorneys test boundaries constantly, trying to lead just enough to shape testimony without triggering objections. Hostile witness treatment. An attorney calls a witness expecting helpful testimony. Instead, the witness turns. They're evasive, uncooperative, or outright hostile. The attorney can't control them with open-ended questions. The attorney asks the judge to declare the witness hostile. If granted, the attorney can treat their own witness like an adverse party, using leading questions, impeaching them, confronting them with prior statements. Hostile witness treatment flips the usual rules. Normally, you can't lead your own witnesses. But when declared hostile, the gloves come off. The attorney can cross-examine their own witness to extract the truth or expose their bias. Prosecutors use this when a witness recants or refuses to cooperate despite prior statements. The witness told police one thing but now claims they don't remember. Hostile designation lets the prosecutor confront them with the inconsistency. Defense attorneys use it less often but can when a witness they called becomes uncooperative. The witness was supposed to support the alibi but now hedges. Hostile treatment allows aggressive questioning. The designation isn't automatic. The judge has to find that the witness is actually hostile or adverse, not just nervous or confused. If granted, the dynamic changes instantly. The witness is no longer friendly. They're a problem to be managed. Motion in limine. Before trial even starts, attorneys file motions in limine, requests to exclude certain evidence before the jury hears it. The goal is to keep prejudicial material out entirely rather than fighting about it in front of the jury. If evidence comes in during trial and gets excluded, the damage might already be done. The jury heard it. A curative instruction might not erase the impression. A motion in limine prevents that by resolving the issue beforehand. Attorneys use these motions to exclude prior convictions, irrelevant character evidence, prejudicial photos, hearsay, anything they think will unfairly influence the jury. The judge rules before trial. If the motion is granted, the evidence never comes up. If denied, the attorney knows the evidence will come in and can plan accordingly. They might address it in opening statements, prepare their witness, or adjust their strategy. Motions in limine also prevent opposing counsel from making improper references during opening or closing. If the judge rules certain topics are off limits, mentioning them becomes grounds for mistrial. The motion is strategic. It forces the other side to show their hand early. It creates a clear record for appeal. And it keeps potentially devastating evidence away from the jury before it can do harm. Manifest necessity. A jury can't reach a verdict. Days of deliberation, and they're deadlocked. The judge asks if more time would help. They say no. A unanimous verdict is impossible. The judge declares a mistrial based on manifest necessity, the jury's inability to agree. The defendant can be retrieved because the mistrial wasn't caused by prosecutorial misconduct or judicial error. It was simply unavoidable. Hung juries are one of the clearest examples of manifest necessity. No one did anything wrong. The jury just couldn't reach consensus. Retrial is allowed, but courts require proof. The judge has to make a record showing the jury was genuinely deadlocked, that additional deliberation wouldn't help, and that no other remedy existed. Defense attorneys sometimes argue a mistrial wasn't truly necessary, that the judge gave up too quickly, that more time or different instructions could have resolved the deadlock. If they can show the mistrial was premature, retrial might be barred. Manifest necessity protects the system's interest in finality while recognizing that some trials can't reach a conclusion. When necessity is real, the case can be tried again. When it's manufactured or avoidable, double jeopardy steps in.